And thank you for joining us for the keynote speech. It's an absolute pleasure for me to chair this keynote and to introduce Dr. Salomon to you. Margot is a friend and former colleague of mine at the London School of Economics, where she's currently an associate professor, and where she directs the Laboratory for Advanced Research on the Global Economy at LSE Human Rights. And I think with her background and her current work, I think Margot is just the perfect person to be delivering this keynote to this conference, given its theme. In my view, she's one of the most important and distinctive voices in international legal scholarship on the questions of global poverty and inequality. Her recent book on the misery of international law with Linarelli and Sonoraja has been really a major contribution to the field. It's an uncompromising take on the contribution of international legal structures to the production of poverty and the entrenchment of inequality globally. And like all of her work, it's deeply informed by the fields of international political economy, critical development studies, and what Margot herself describes evocatively as counter-hegemonic approaches to law. In addition to her writings, Dr. Salomon, Margot, continues to engage in these issues across a variety of international regimes and spaces. So she's been a consultant to the Office of the UN High Commissioner for Human Rights on extreme poverty and human rights, to the World Bank's Nordic Trust Fund on human rights and economics, and an advisor to the UN High-Level Task Force on the Right to Development, as well as the ILA's Committee on the Rights of Indigenous People. So a real wealth of experience and depth of thinking on these issues. And Margot is going to speak to us today on rethinking distribution for social transformation. She's going to speak to us for about 30 minutes or so. After that, we'll have some time for Q&A. Please make a note of your questions as Margot speaks. There will be a Q&A box into which you can type your questions at the end, and I will be reading them out to Margot. And if you do that, if you prepare your questions as Margot speaks, we can use the time that we have, I think, to the full. So thank you to Margot, to Dr. Salomon for being with us, for agreeing to deliver this address, and over to you.
Thank you, Andrew, very much for that wonderful introduction. And it's very nice to be together again. It's been a while since we've seen each other, even if only online. And of course, my warm thanks to Anna and to Gigi and to the entire organizing committee for the tremendous effort that they put into this conference. As we know, it was postponed and there's been very trying circumstances and they've managed to pull it together. So that's fantastic. And of course, a great thanks for the invitation to share my ideas with such a wonderful group of scholars. So I think it's great and I'm delighted to be here. So in his concise treatise, Poetry for the Future, the Croatian philosopher and political activist Srećko Horvat seeks to unearth what resistance and transformation require, given, as he frames it, the threats to humanity, ecological disaster, subjugation to capitalism, and techno-totalitarianism. Horvat draws his central message from the Yugoslav partisan movement during the Second World War and the way in which the partisans used the misfortune of occupation to mobilize the population, not only against fascist occupation, but towards social transformation in the wake of the Second World War. We need to appreciate, Horvat urges in his lesson on post-capitalist praxis, that there's never a moment when all conditions for making revolution exist. In the here and now, one can speculate as to whether COVID-19 will spur disruptive possibilities. The pandemic's tragically familiar unequal impacts across race, class, and gender, within and between countries, has smashed the thin illusion of shared progress and prosperity that has long been peddled. Perhaps it will open up space, provide novel entry points, and unleash pent-up anger that can be directed to transcending the pre-pandemic world marked by great poverty, inequality, and a model of advancement premised on the exploitation of humans and nature. Or perhaps it will not. And one reason it may not is that while the COVID-19 pandemic has highlighted the limits of the market from the poor outcomes of countries with robust public health care to large government subsidies required for vaccine research and development that the private sector was unable or unwilling to cover, this fact risks prompting progressive voices to claim that the government, that the state, and not the market is the only viable solution to some of our greatest challenges. But maybe with transformation in mind, in fact, what we need is to move beyond the state as much as the market. So my provocation in this lecture is to table the following premise. What if rethinking international distribution for social transformation requires that we think beyond capitalism and beyond the state? And what if thereby necessarily it requires that we think beyond international law? In taking up Horvat's plea that the time to act is always now, I'd like to excavate chronic malaise embedded in our discipline and direct us towards revolutionary lawyering in the interest of social transformation. We face a serious difficulty with international law. So the topic of this conference, International Law and Distribution, is timely, but it's timely in a perennial sense, in that the problems identified are permanent under conditions of enclosure, extraction, and exploitation of private property and commodification. Let us consider first some familiar manifestations of these problems. The ushering in of the Anthropocene, pesticides, plastic, pandemic, rapid urbanization, widespread hunger, with the greatest majority of the hungry being women who work in agriculture, the subjugation of the countryside and its people by the interests of capital, peasants, indigenous peoples, small-scale farmers and fishers, agricultural workers, landless people, the obliteration of culture, extreme wealth concentration with the attrition of democracy among its dire consequences. The exploitation of people, nature, and natural resources is the model for human flourishing that has been endorsed by the institution of international law. International law has always been a powerful vehicle to globalize the exploitation of humans and commons. International law continues to facilitate and legitimate those practices while it delegitimates alternatives. The standard tropes that accompany this model and that disintegrate upon further examination are that the world has never been richer and the human race has never had it so good. Responses and pushback take the form of international law could be made to do good if only. If only there was greater accountability at the international level, whereby a system that has distributive justice and policies of redistribution conventionally associated with the internal affairs of states would recognize the importance of justice and accountability also at the site of international law. If only the discredited system of investor-state dispute settlement would be reformed, allowing for the site of justice to be nationalized through the use of the host state's domestic courts to resolve investment disputes, or new rules on exhaustion of local remedies prior to accessing investor-state dispute settlement. If only we can extend the moratorium on sovereign debt repayment during the pandemic. If only we could get a waiver to temporarily suspend intellectual property protections needed to address COVID-19. If only we could ensure permanent restrictions on any investor-state claim related to government measures targeting health, economic, and social dimensions of the pandemic and its effects. A central problem here, whatever the urgent need and immediate benefits, is that these extraordinary measures, as U.S. Trade Representative Catherine Tai put it when announcing that the U.S. would support a TRIPS waiver, does precisely nothing to displace the hegemony and asymmetry that characterize the global economic order. Any official turn merely to temper capitalism's necessary practices that chronically injure the least well-off among us does not represent change. It's an extension of what international law has always been, and fundamentally a reaffirmation of it. But for today, I'm interested in exploring a different question. Part of the trouble with if-only efforts, such as the ones described, is that they assume that international law can be fixed, even if it might be very difficult to reach the necessary degree of reform in order to make it desirable. And second, that ultimately it's better than its alternative, this being portrayed as lawlessness, violence, and war and disorder. For the post-capitalist lawyer, for the international lawyer committed not merely to amelioration of the human condition, and it's questionable as to whether even that is likely in a meaningful way under the current system, but to its transformation, international law cannot be fixed in a fundamental sense and needs to be rejected on the basis of its connection to capitalism if one is serious about change. What we have now as a general remedy is a compensatory mechanism for capitalism's ills in the form of some kind of redistribution. Socially necessary redistributive policies and marginal tax increases on obscene wealth nationally, that is, the transfer by the state when it happens of the proceeds of the capitalist growth economy. Internationally, perhaps we'll see a global minimum corporate tax rate take hold, and the negative impacts that capitalism produces have given impetus internationally to some kind of grand narrative that points in the direction of social safety nets, for example, the international commitment to national social protection floors in the Sustainable Development Goals. These efforts may be ameliorative, they may even be considered fair, but they are still and always an evaluation of what is fair on the basis of a particular mode of production, capitalist production. And one need not claim to be a Marxist to foreground, as the sociologist David Garland does, that the welfare state and redistribution is, as he puts it, an ancillary institution, an outgrowth of a system of market-based distribution premised on private property and the transactions of property owners. So I ask, is this really the limit of our imagination? Our imagination is constrained by the connection between capitalism and international law and the boundaries set by international law. Let's consider those parameters. International law presupposes private property and the arrangements necessary to protect them and to profit from them. As the Soviet jurist Pashukanis points out, the existence of a commodity and money economy is the basic precondition without which all these concrete legal norms would have no meaning. The rules, that is, the content of international law, are derived from that particular relationship. Elucidating the point, China Mayville situates the rules as secondary. In fundamental jurisprudential terms, their specific content is contingent on that first order relationship. Our mistake, then, as revolutionary lawyers, might thus be that we conceive ourselves as law's creation, which leads us rationally to think that if we change law, we would change the world. But as Isaac Balbus points out, that inverts the causal relationship, whereby society is held to be the result of law, rather than the law to be the result of one particular kind of society. That is, a product of capitalism. Now, this is not to suggest that economic interests are all that matter in international legal relations, or that the content of international law cannot reflect public interests, or that the judicial interpretation of rules cannot favor the disenfranchised, but it is to highlight how law must be explained by the systemic requirements of capitalism, its presuppositions aligning with the rapacious and endlessly expansive and exploitative features that make up capitalism. This Marxist theorizing helps us to take seriously the question, what are the implications for social transformation if law is not autonomous from the capitalist system? There are other critical approaches that lead to the same conclusion or similar conclusions. Hugo Mattei and Luigi Rossi, in their compelling article on international law as the evil technology, in the evil technology hypothesis, depict international law as a depoliticized technology, a means to facilitate ends, the positive value of which is assumed. Consider here the commitment to a rules-based international order. We know, however, that historically and currently international law has always been a mighty support of brute power by providing a facade of legitimacy to domination. And we know that the received wisdom as to the value of a modern rules-based international order is meaningless in that it tells us nothing about the quality of those rules, who they protect, what interests they promote, the global order they prop up, the harms they apportion, the possibilities they displace. And we know that the adage of a rules-based international order is dangerous because it carries with it a potent normative assumption as to its unassailability, juxtaposed as it always is against the harsh alternative of a lawless system where might makes right and anarchy reigns. We know also that international law has functioned as a very powerful engine for transforming commons into capital and for elevating some at the expense of others. What international law is and does begs an appraisal of alternative possibilities that it has foreclosed. And we are prompted to take seriously the questions as to whether we should accept it at all and what would replace it. These arguments, these two set of arguments presented coalesce around a key point for our aims today, that international law itself may be the problem, not merely some biases within it that just might be undone, if only, and not due to the inability of advocates to make it serve different ends. So before turning to how we might approach real solutions, let's unveil a few prominent approaches deemed solutions, whereby acceptance of the capitalist logic plays out under the guise of emancipation and change. I'll begin with a comment on the new international economic order. So as many of you will know, or are familiar with, the new international economic order was the high point of the effort of third world states at deploying an international law that had long been denied them. And in the wake of political decolonization, the new international economic order reflected a further rejection of colonialism, an effort to assert the sovereign autonomy of the non-Western world, and it was an attempt to redirect international economic governance towards distributional equity and fairness. And we know, of course, that the West challenged the terms of the new international economic order, unwilling to have decolonization unhinge imperial control over natural resources and markets. Indeed, in a wonderful intellectual history of the period provided by Christopher Dietrich in his recent book, Oil Revolution, we see a truly cynical negotiation strategy of the US at the time. The policy of the US State Department was to direct negotiations toward, quote, a long-term and evolving North-South dialogue in ways that will improve rather than fundamentally change the international economic structure. I say it was cynical, not because the US interpreted improvement to mean cooperation, emphasizing the role of private capital and the expectation that developing countries would improve their investment climate when those countries were after economic self-determination and participation in global economic governance. I say it was cynical because to improve rather than to be open to fundamental change is precisely a strategy of co-optation aimed at kicking transformation into the long grass. It is, at the end of the day, a strategy to embed further the status quo under the guise of improvement. Yet, and this is key, critics of the day always understood the new international economic order demands to be reformist and capitalist, premised on capital accumulation, on the continued exploitation of natural resources and of labor in the periphery, and the institutionalized collaboration with foreign capital. Herb Addo, a prominent international political economist at the University of the West Indies, was writing at the time, quote, if we If we're interested in transformation, not reformation, then we need to judge the newness of the new order on the extent to which it amounts to a radical departure from the historic theme of capital accumulation in pursuit of world capitalist motives and the conflicts they engender, both at the national and international levels. The movement from an exploitative and therefore dehumanizing world system to a non-exploitative and therefore humanizing world system. Crucially, Addo drew attention to the sharp distinction between anti-regime forces and anti-systemic forces. And it's a question posed by this address whether systemic change is possible under international law. Another example of a prominent purported solution comes in the form of benefit sharing, familiar to international human rights law, my own area of specialism. So, in 2018, the UN General Assembly adopted the Declaration on the Rights of Peasants and Other People Working in Rural Areas. It was a hard-fought for and widely celebrated declaration that emerged in response to the impact of globalization on peasants and other people working in rural areas. It constitutes an attempt to salvage relationships to land, water, and nature to which peasants are attached and on which they depend for their livelihood and way of life. The declaration articulates the claims of peasants given their commitment to small-scale and sustainable production, to food sovereignty, and agroecology. There are novel rights in the declaration, and they include, as part of the right to an adequate standard of living, facilitated access to the means of production, as well as a right to engage freely in traditional ways of farming, fishing, livestock rearing, and forestry, and to develop community-based commercialization systems. There's a right to seize, which includes the right of peasants to save, use, exchange, and sell their farm-saved seeds or propagating material. This is in order to redress the commodification of seeds by the powerful foreign agri-food sector, including engineering seeds with non-renewable traits that cause them to die, requiring poor farmers to buy new seeds for every planting season. But the declaration also requires, and I quote, modalities for the fair and equitable sharing of the benefits of exploitation that have been established on mutually agreed terms between those exploiting the natural resources and the peasants and other people working in rural areas. Through the technique of benefit sharing, the alienations and antagonisms produced by capital accumulation are merely managed, and the solution, so-called, becomes an indispensable aspect of sustaining the processes of capitalist exploitation and accumulation. Moreover, advocates of alternatives to the logic of private property exploitation and accumulation are effectively silenced. This alleged solution of benefit sharing found in the Peasants' Declaration is not unusual in the human rights field. It's a solution deployed in the area of Indigenous land rights to remedy impacts from commercial incursion. But there's a real risk that arrangements to come from participation in the design of a benefit sharing scheme require acceptance of the capitalist logic of natural resource exploitation, moreover, often in contradiction to Indigenous and local culture and way of life. Like Addo's rejection of any model that imitates and institutes the very exploitative nature of the world economy, benefit sharing comes at a cost, the cost of masking the structural subordination at the heart of contemporary capitalism, just as it contributes to its continuation. And it draws into global capitalism some of its most passionate opponents and those with the greatest experience to spearhead alternatives. So how might we begin to think about real solutions? Based on an ethnographic study of Indigenous peoples from the Southern Highlands of Ecuador, undertaken by the anthropologist Erin Fitzhenry and published recently in the Journal on Human Rights and the Environment, Dr. Fitzhenry highlights that the group's demands are not for shares of the wealth generated by mineral extraction, but shares in decision-making processes about alternatives to extraction. even while Ecuador, she writes, has explicitly underscored the importance of resource extraction to the expansion of a range of social welfare programs and the promise to keep profits nearer the communities that host extractive projects. Affected communities are nonetheless rejecting the distributive politics of the extractivist state altogether. In other words, I suggest that reform is off the table and nothing short of revolution will do. International law fails to meet the reasonable expectations of those whose lives are regulated by it. What we have and need to challenge is our utter alienation from international law as a professionalized legal order separate from its communities of users and makers, as Capra and Mattei express it in their book, The Ecology of Law. Or drawing on Vito De Lucia, what is needed is to establish an equivalence between users and caretakers of law. Bottom-up visions and practices are emerging, ones that reject competition, hierarchy, and greed as organizing principles of national and international society, the byproducts of which are meant to be enjoyed by all. Instead, gaining traction are not only democratic counter-movements, but models of social organization committed to economic democracy and to structures that return law to the people. In an article I recently completed with Ugo Mattei, tentatively entitled From Poverty to People's International Law, we conclude as follows. Poverty, inequality, and exploitation of people and nature will not recover under international law and will not recover until international law is fundamentally reinvented. Social transformation will not begin with international law and will not be delivered from above, even though international law requires constant vigilance and confrontation. Reinvention will have to be from the bottom up, and in all those places where collective agency is exercised by the people rather than on behalf of or without the people. Thanks very much.
Thank you so much, Margot. So, Dr. Salomon has put a lot on the table for us. So this was an address which encouraged us to think beyond the state as much as the market, so to look for solutions outside of state institutions, which put a series of really large questions on the table for us, really including the relationship between international law and capitalism. And as part of that, I guess, the question of thinking about the logics of a social phenomenon such as capitalism and whether it is useful to think of it as having a singular logic. The plasticity or otherwise or structured nature of the legal form itself, the international legal form. And then I guess towards the end there, the largest question of solutions and what solutions and indeed critique looks like when one takes a view of the global economy as deeply structured in this way, right? So these are some of the biggest questions that I guess, are raised by the theme of the conference, are raised by your work, Margot, and really ought to be on the table for us here. So thank you so much for that. A really provocative discussion and a lot there for us to think and talk about. So as indicated earlier on, the format now is for those of you who wish to raise questions to begin to type them into, into the Q&A box. And I believe all of us can see the Q&A box. Certainly I can now. And I'm seeing one already there from Gail. Thank you so much, Gail. And as others come into that Q&A box, I will simply just read them out to you, Margot, and you may well be able to see them there as well on your screen. So Gail raises a theme that you raised early on in your address, Margot, about COVID-19 and its distributional impacts. And you talked in actually somewhat ambiguous terms about whether COVID-19 represented an entrenchment of existing inequalities, as I think is probably generally understood, or maybe even contains some elements of potentially open futures. And Gail asks about the concrete steps that international lawyers and international legal scholars can contribute to those disruptive open possibilities post-COVID-19. So can I ask you maybe to say a few words in response to that? Thanks.
Yes. So one thought is that there's this, of course, there's this moment of rupture. And so part of what I was trying to highlight was, to steer us away from the sense that what seem like dramatic steps and are hugely important steps at the moment, that list I gave of, the waiver and suspending debt payment and all these things, of course, they're monumental and extremely important. But so what I'm trying to steer us away from as scholars, as much as activists, is not to settle for that and to recognize that, as important as they may be, right, in real terms and in real time, to recognize that we are, in a sense, reaffirming the status quo by engaging merely at that level. So, one way of thinking about this is about, in a sense, perhaps a two-tiered approach that recognizes the significance of those immediate steps and the urgency of those steps. And civil society, broadly understood, including academics, have been huge behind getting those things on the table, as you know. But at the same time, whether it's in our scholarship or our activism or our lawyering, or our practice, that we recognize that there's something far bigger at stake. And if we settle for that kind of seemingly revolutionary move of suspending all these usual practices that are so, oppressive and have been contested for so long, if we see that as the end game, then I think we're losing the chance at what becomes possible in a period of rupture and a period that opens change. And it brings to mind maybe analogously the sort of the movement, a couple decades ago, sort of poverty lawyering in the US, where there was this, wonderful scholarship, and also a little bit more recently, it's come up again. So the idea there was really to think about, how, and it was about pedagogues and practicing lawyers and public interest lawyers who were dealing with poverty on the ground and representing clients on the ground, and were concerned both about the well-being of their client, in winning the case and addressing the rights and so forth, and remedying the rights, but also about the structural causes that gave rise to those problems in the first place. And their concerns were that through that lawyering process and the focus on the individual client, that they were losing sight of these greater structural issues. And so there was a movement intellectually and practically that came together to make sure that in the process of remedying immediate harms, that there was an awareness of and a way in which they could lawyer that brought alive the structural problems that gave rise to the harms, and particularly, and I think most importantly, recognize that the harm to the individual was in fact not an individual harm at all, right? That it was a harm that was part of a much bigger cycle, and there were many individuals similarly affected. That it really wasn't about the individual at all, except insofar as the law structured, the remedies in those ways, and they were working within those parameters. So the point really is just that we engage, but we recognize or we avoid, what one scholar writing at the time talked about as micro worlds, that we don't limit our attention to the micro worlds, but we're aware of the macro environment, and through whatever avenues we see fit, that we don't settle for the status quo, even radical status quo, as some of these, developments have been within COVID, and push further to unsettle, the structural underpinnings that made it possible, and that even are reflected within those quasi-radical steps of the if-onlys.
Sorry, I had muted myself there. Thanks, Margot. So you will see in the box there that Tilman Altviker has raised a couple of different further questions for you, and as you read them, I'll repeat them out. So I think there's two here, really. So one has to do with whether the relationship, in Tillman's terms, are all parts of international law to be equally compromised? So in other words, so should we see the relationship between international law and inequality/poverty to be variegated across different fields of international law? And I guess from your talk, I took, it sounds to me like you deliberately took some of the more of the projects which would typically be characterized as the transformative side, and showed that they are, and show that in your view they're not. So I take that to be the core of your answer there, maybe, but I'd be interested in your thoughts. But then there's a second question there from Tillman, and I do think it's somewhat different, which is that he says, is the problem you identify on the basis of the norm or on the basis of its interpretation? And so I think that gets at this distinction between the norm and the interpretation. We might formulate it in a variety of different ways, the structure or the practice. Is it something deeper, or is it something which is the relationship between international law and its distributive consequences something more contingent, or something deeper, more structural to it? That's how I understand that question. I think I'm going to ask you to respond to those questions before I come back in with Matthew's.
Yes, thank you, Andrew. That's good, because they're meaty questions. And I hope you could hear me during the talk, because there was this spontaneous rainstorm on my roof, and I couldn't hear myself, but that didn't seem to bother you. It was fine. Okay. So is it all parts of international law? So here's the sort of a bit off the cuff answer. So yes, it is. The easier way, it doesn't make it insignificant, and it's largely the way it's sort of the direction I'm leaning in with this talk, is to focus on international economic law, because it's a sort of straightforward target in that sense. So I think that's fairly clear cut, although of course we could unpack it in many ways, and I should be careful what I say with Andrew here, because we could open up a debate that invariably he'll win. But so we have international economic law, right, as one obvious thing. If we look at some of the, if we look at the work of Pashukanis, what's interesting there is, looking at the commodity form theory, is that he actually focuses on international law in the main, right? And he talks about the way in which, sovereignty is analogous to property, and that states basically come together as capitalists, trying to advance their particular interests as capitalists on the international stage. So in that sense, we could really unpack, a la Pashukanis, the ways in which international law in and of itself is structured in a way that mirrors those capitalist relations. In terms of human rights, there's a lot there. So I could, at the risk of, I want to avoid contradicting myself. I'll say one thing about human rights. The problem one of the problems, let's say, is that, and it goes to probably your second question as well, sort of part of the problem is that the interpretation of socioeconomic rights generally has, by the bodies that interpret socioeconomic rights, there's been a lack of awareness, in my view, and I say this with a huge amount of respect for many of them who are dear colleagues of mine, but in some ways a lack of awareness of the way in which they, on the one hand, seek to redress all these grave harms, world food crisis, and and housing stuff under austerity and everything, all this kind of socioeconomic problems. And they're very alive to sort of progressive approaches to that. But the answers always tend to be, we need, there's been more growth and we need more growth in developing countries, and that growth has to be redistributed. So there's no awareness of or engagement with the ways in which socioeconomic rights are addressed, the redistribution argument, right, which has to be confronted head on, because the funds for that redistribution is coming from an existing system that's reinforcing the problems that you're seeking to address. So there hasn't been engagement at the deeper level. There's been a sort of, in a way, extremely important but relatively superficial engagement with, raise taxes and bring in taxes and address flight and redistribute more and make sure the proceeds of growth are better and, tax corporations. But it's remaining at this level that does nothing to unsettle the system generally. And as constantly reaffirming and perpetuating the problems that they seek to address. So that's sort of some of the stuff I wrote on in the Misery of International Law. We wrote, in the Human Rights chapter and earlier. So I would say, in different ways, and depending on the entry points, we could probably talk about this in all terms. And in that way, I was a little bit vague, maybe in not using the term international economic law, because I was capturing at different moments, sort of different regimes. So I hope that's something of an answer. Is it the norm or the interpretation? So here's my sort of provocative point, and that is, so maybe I don't answer that in a straightforward way. What I'm trying to say is that the best we can do at this, what Patrick Hannes, but also China Mayville talks about, right, as the second level area of law, is that it's, the best we can do is be radical within those parameters, and that would be sort of the norm, and its interpretation. And what we're not dealing with is the way in which law, the way in which capitalism explains law, right? The form of law, if you will, that everything that emerges has some link to capitalism. And even if the norm, seems progressive, it was shaped within and shaped against this capitalist background. So we can think about something like some of the progressive and important jurisprudence that's come out of the Inter-American Court of Human Rights on indigenous land rights and the reinterpretation of the right to property, which is the right to private property in the American Convention on Human Rights, and it's reread as the right to collective use of indigenous land. So it's not private and it's not owned, but it's theirs and it's demarcated, and that's right progressive, and that's a move in the right direction. And so we have this conventional norm and this progressive interpretation. So we're definitely moving somewhere. And what I'm trying to think about, and I don't, it's not fully fleshed out yet, but what I'm trying to think about is what is the pre-existing norm against which that norm is, that interpretation is being applied, right? What comes first? What are the sort of the first order principles against which everything else develops? So we're responding to, if you will, a set of norms that are steeped and descriptive of and aligned to capitalism, and we're working within those parameters. And what I was trying to do was to say, well, what if we weren't working within those parameters at all? What if we weren't circumscribed in our possibility, in the norms we have, because capitalism is assumed in the making of those norms. Capitalism is assumed by the states negotiating, and those norms. Capitalism is assumed by the bodies interpreting those norms, and when they do it progressively, it's against the background of capitalism. So what if we didn't have that capitalism as the frame, as the boundary within which we think about international law?
Thank you. Do you know, I think that discussion at the end there, prompted by Tillman's second question, is really directly relevant to Matthews as well, who asks a similar but slightly different question in different terms. So he raises this concept of prefigurative politics, which I take to raise, I guess, the question of the performativity of social practice generally, right? This question of performing present-day life in the terms that are wished for, in a sense. The sort of, he refers to the bottom-up work that you mentioned at the end of your talk and what form that might take. And the question there is, do you have faith in prefigurative politics to redeem international law? Or would you side with those who think that prefiguration presumes a future salvation that might not be forthcoming? Margot.
Mm-hmm. It's a nice question. So recently, I was Davina Cooper's work was brought to my attention because I've been, and I have to admit I hadn't come across it before, I was doing research into, and I still am, sort of the end of this talk is sort of the beginning of some things that I'm thinking about. So research into, what would international law look like without the state? And so I'm looking at some of the very interesting writing on, different formations and sort of the ownership of law, not only the ownership of alternative institutions, but also an alternative to the institution of law as we know it, and how that would get scaled up. And Davina Cooper wrote this piece in one of the blogs. She wrote a blog, very interesting one, maybe Critical Legal Thinking or somewhere like that, recently. And she was making the case that the state is essential, and not sort of in a purely practical sense, that how would we do without the state kind of thing, but that the state could have a very particular role to play and could be reconfigured to advance these progressive or radical ends. And she had quite an interesting thesis there. And part of it was that we have to engage and we have to sort of prefigure what we want and sort of invent it through the process of invention. And so I guess don't have a strong view on that. In large part because I don't think I've engaged deeply enough to take a firm position. My and I know this is being recorded, so I guess I have to be careful, but my intuition or my sense is that, I guess maybe twofold. So one of it is that, doing is important, right? Just doing and moving towards something that's different is extremely important. And I guess it speaks to sort of the point I was making from Horvat's book, that there's no time like the present for revolution, and we can only get there from here. So there's always a way to start and a place to start. And it's in a way not, I think it would be presumptuous in a way for me to prejudge what that movement could look like. So in that sense, I guess I'm quite open, but I would counsel against, and this is in a sense restating what I said before, I think awareness of the implications of those decisions, what they have for the greater transformative aim, is important. Because some of those steps that seem progressive or radical at the time preclude real change. And so I think part of it, and that's what I talk about when I use the language, for better or for worse, of the revolutionary lawyer. It's not that we're, in whatever terms you imagine it, committing revolution or being revolutionary at the time, but in our thinking, we have the idea of that kind of change in mind. And so the steps we take are alive to the change and opportunity that we foreclose in taking those steps that at the time seem extremely significant or progressive. So I think everything's on the table as long as we do it with our eyes wide open. So that we don't inadvertently undermine the radical or revolutionary project that is our ultimate aim. And that makes me think, in a way, just as a link to some of the work that Rob Knox has done on tactic and strategy, that foregrounds that same kind of thing.
Thank you, Margot. So there's a wonderful question here from Charlie. Anna, I know, has one, and I have one. Now, obviously, we don't have time for all three of those. But what I'm going to do is, if you don't mind, Margot, I'm actually going to get all three of those questions on the table, and then you'll just have a few minutes to pick up what you can from those. But I just want to get the themes on the table in the way, because I think that's part of the purpose of this. And so, firstly, just quickly, so firstly, Charlie raises the question of rupture. Who makes it, and what you mean by rupture, or what you mean, I think, here I am interpreting, Charlie, your question, what you mean by transformative, something which is truly transformative. Charlie also at the end of her question there puts in the terms of the distinction between the spectacular and the mundane. Can you say more about how rupture itself is understood here, as it feels like it orients importantly towards solutions? Okay, so this is the question of how you conceive of that distinction, I guess, between the spectacular and the mundane, the rupture and the continuous, the transformative and the not, and so on. Great question. I wanted to put on the table, and again, just to pick up if you have time or thoughts on it, just to pick apart the term capitalism, and just to put on the table a couple of points about that, I guess. We know from a variety of different sources, I mean, from within the milieu that you are talking about, even from someone like Nancy Fraser and so on, that capitalist forms are variegated, change over time and so on. So I'd be interested in your thought. But capitalism, I think, emerges from your analysis as quite a strong structural and almost not an entirely stable force, but nevertheless something quite determinate. And I'd be interested to hear your thoughts, if you, to the extent that you are able to articulate them in the limited time left to us, on the nature of the changes and variations that we see within capitalist forms, the dynamics, and also in particular the role of law and international law in those dynamics, right? Which would be the second half of the story that you tell in a way. And then, so there it is. And then, so that's sort of the question of capitalism, its internal dynamics, its variations, its changes over time. Anna, can I call on you to jump in with a question of yours?
Sure. So my question was, we've seen in recent years what a colleague of ours here at Glasgow, Henry Lovett, terms backlash against international institutions. And there are varying causes of this backlash, and many of them are not necessarily friendly to, shall we say, progressive causes, but might be even tending towards authoritarianism. However, we might say that a common trend is a move to relocate elements of governance of the economy to the national level, or more to the national level. And I was wondering if you thought that there is any potential politically, if the international order that you've been talking about is in some ways being shaken or disintegrating, even if those causes are not, shall we say, friendly to the same cause, but in relocating some of that governance to the level of the nation state. Thanks.
Sorry, Anna, your last point? The final point of your question?
Yeah, so whether you see any political potential, if despite the reasons why there's this fragmentation going on, or this shaking of the international legal architecture, if we want to term it that way, whether you see any political potential in this move to relocate some elements of governance of the economy back to the level of the nation state.
Okay, so these are fantastic questions and huge. Okay, I'll say a couple of things that come to mind. So the backlash against international institutions. So one could say that nationally, that it brings the possibility for political engagement closer to home, right? I think, and now this is sort of more of a conversation to have over coffee rather than a conference, because it's quite speculative. But I think one of the repercussions of a whole host of factors, but in a way factors that sort of coalesce around the ideas that I've tabled here today, is that democracy has been undermined, and it would be in a way, political scientists and others to consider the way in which bringing those elements home create a more fertile terrain for strengthening the kinds of progressive developments that we want to see developed. What I will say is that I'm keen on thinking beyond that. I think there's if I look at some of the countries that I've spent time in, government and the state is really discredited in very fundamental ways. I think what we're seeing now also is, high levels of really what can be called corruption, and problems with, deep-rooted problems with democratic accountability. I think part of this counter movement is really reclaiming, is about political democracy and economic democracy, and about unsettling and decentering the state. And so part of that conversation will be about what role there is for the state after this. And Davina Cooper's stuff situates the state quite centrally. There's a really interesting literature on new municipalities that really bring home ownership at the smallest unit within a country, and through that process, because it's a small, allow for all sorts of different schemes, cooperative schemes, collaborative schemes, non-commercial schemes, reclaiming the commons, reclaiming banks, reclaiming public assets, and schemes of collective ownership, collective housing schemes, and all kinds of things. So part of this is just how we reclaim, and whether it's possible through the means that you've suggested. I think on the other side, and I see we're running out of time. On the other side, international law doesn't really do democracy, right? So it's one state, one vote in the UN, and some system like that. But the point is that you're equal once you claim to be a state, and there's some modest recognition that you get a seat at the table, broadly speaking, right? The fact that whether you've come to power through a coup, whatever's going on at home, until it reaches a pretty high threshold, and even then it's overlooked a lot, right? So democracy, international law doesn't consider that democratic process. So once you get up there, there's all these different players, and whether the degree to which they're representing the interests of their people is an open question, and that goes for North and South in many ways. So I think there's a lot in terms of democratic ownership to contend with internationally, and I think bringing it home domestically, we're still dealing with the state, and I'm inclined to look at the shift towards decentering the state, and then there's a whole spectrum of what that would look like, but I think that would be an important way to go, or at least to review. So Andrew, capitalism and its the nature of changes, and so what I think about here in a very brief sense is, and drawing on the literature that basically again sees this spectrum that says we move from a liberal maybe to a neoliberal government, we move from a Keynesian to a to a neoliberal or far more market-oriented government. But there's this, we're circumscribed, and over time the different pressures internationally, and there'll be changes over time, but really we have particular parameters within which we move, and what I'm trying to talk about is how do we think about moving outside of those parameters, which really don't move beyond these two ends, and how has international law made it impossible to do that? So while there's a lot to unpack around capitalism and its historical trajectory, it's circumscribed by particular assumptions and particular and in the practice of capitalism, particular ways of governing that hasn't changed radically, and takes for granted certain assumptions. And so those assumptions, I wonder about unsettling those very assumptions, regardless of this, the type of practices that's being engaged with. And then Charlie, your question was long and I couldn't read it. So I don't think I'm going on what Andrew said. And I don't know if I'll even answer it. And it's not a great way to end. I'd love to just read it more carefully. But something about between the spectacle and the mundane, and the transformative and the not, and the rupture. Andrew, can you tell me with a minute, in the last minute, or should I take a look myself?
Sorry, I was muted.
Do you know what the gist of it is?
I can. So it's at the very top. It's been moved up to the very top of the Q&A box.
Okay.
And Charlie asks if you could say a little more about how you conceive of rupture, who makes it, and how you're thinking
about it. I have in mind here the counterposing of the potential of rupture with the co-optation of that through the proliferating spectacle of crises. The latter feels the more human mode of reaction and renewal to do good and be useful in the wake of crises. And your talk speaks to, in part, these boundaries. I could say more about how rupture itself is understood here and how it feels. Okay, so you raise a lot of a lot of different issues. You make me think about, Hilary Charlesworth and her famous stuff right from 2002 on international law and crises. I think, I do think that there's far greater awareness of structural dimensions, right? That crises is one thing. So for what elements of socioeconomic issues are prevalent now, right? These are no longer fringe or marginal. It's not this sort of the poor brother of civil and political rights, and it's dealt with across the board. I think some of the structural and systemic problems are widely recognized, through various disciplines, but also within international organizations in many ways. I mean, I think we've come a long way in moving from crises as flashpoints to an understanding of this sort of systemic and grinding problems. That's the whole Sustainable Development Goals, and all this stuff is recognition of sort of these grinding problems. So in some ways, the crisis thing, I think, is not the core issue. I think that the issue is that there's endless, and really I mean endless repetition of the kinds of problems that we've always seen. And, I've written on sort of the austerity and the debt crisis in Greece and stuff like that. I mean, this was really, shocking in the way in which, the people of Greece were subjugated during that process. And this was, 30 years, 40 years after NGOs and activists were screaming about structural adjustments and the impacts in Africa. And literally nothing has changed. And if you look at the recent work coming out of Eurodad and the people writing on, the pandemic lending by the IFIs and so forth, and the conditions attached to it, it's really as if, we're screaming into the night here. So I think there's a huge awareness about structural and coming together and the underlying issues, and international law and policy makes a lot of noise in that direction, and so on. But in very fundamental ways, I don't think there's been meaningful change. And I think in a way that we have to assume perhaps that no meaningful change is possible. And part of what I've done here is to look to why, not just at the level of practice, but at the level of structure, to see whether whether we have to give up on what we have and start anew, and what that might look like as international lawyers.
Thank you so much. And looking at the time, we do have to call it to a close. Alan McKenna, I'm so sorry that we didn't get to your question, a great question about entrepreneurial subjectivity, the competitive spirit in a sense, and how that plays in to this story. So I apologize that we couldn't get to that. It's been a really rich discussion. I'm really pleased that this keynote, your keynote, Margot, was scheduled now. I think it sets the stage for the next 2 days. Really raises up. In this conversation, I think we've raised a whole series of themes which will continue to recur, I think, and really speak to the presentations over the coming days. So thank you so much for that. I think you've really raised a number of these issues in a tremendously powerful way. And I was told I should say before this that you've just had your vaccine. So and I know that can hit you for 6. So that's a particular accomplishment. Congratulations for getting the vaccine. And then for delivering such a wonderful talk on it. And so thank you so much for that.
Thank you.
Thank you everyone for your questions, and we'll see you in the coming
Thanks, Andrew.
Thanks, Margot.
Thank you. Thank you.